Bankruptcy Module 1. Overview of Bankruptcy. Overview. A fresh start. That's what Pip wasn't afforded in the Dickens novel, Great Expectations, as Dickensian England sent people to prison if they couldn't pay their debts. By some estimates, more than half of English prisoners in the 18th and 19th century were imprisoned simply because of the inability to pay their debts. While debtor's prison is a thing of the past, our society goes even further, allowing people saddled with unmanageable debt to get clean slates under certain conditions. The clean slate, of course, is known as bankruptcy. We'll be using the term bankruptcy in this course to mean cases filed under one of the chapters of Title 11 of the United States Code, the Bankruptcy Code. A person or organization that files a bankruptcy action in federal court has declared bankruptcy. The person or company declaring bankruptcy is called the debtor, and the person or company to whom a debt is owed is called the creditor. Filing a bankruptcy creates a bankruptcy estate, which includes all legal or equitable interests of the debtor at the time of the bankruptcy filing, even if the property is held by another. Though the goal of bankruptcy law is to give the debtor a fresh start, and people usually declare bankruptcy when their debt load overwhelms their ability to pay that debt, there may also be other reasons to file, as we'll discuss a bit later. Bankruptcy laws and regulations are complex. We'll highlight the bankruptcy laws that are most relevant to most people and present them in an understandable way. Bankruptcy law allows the debtor to either eliminate a debt, which is called a discharge or liquidation, or to arrange to pay debts over time, which is called a reorganization or rehabilitation. Bankruptcy statistics. In the 12-year span from 2005 to 2017, about 12.8 million consumer bankruptcy petitions were filed in federal bankruptcy courts. Of those, 8.7 million, or 68%, were filed under Chapter 7, and 4.1 million, or 32%, were filed under Chapter 13. Non-business filings, which means filings involving mainly consumer debt, constituted 97% of all Chapter 7 bankruptcies and 99% of all Chapter 13 bankruptcies. Business bankruptcies accounted for about 13% of all filings under all chapters. Total numbers of bankruptcy case filings decreased every year from 2010 through 2017. However, bankruptcy filings by seniors aged 65 and over increased dramatically from 2013 to 2016 at a rate that was 3 times the rate in 1991. History and structure of U.S. bankruptcy law. Bankruptcy law is federal law, but the workings of a bankruptcy case may involve state laws as well. Bankruptcy law is authorized under the United States Constitution, which empowers Congress to establish uniform laws on the subject of bankruptcies throughout the United States. The idea and basic processes of bankruptcy law predate the founding of the country. Over the centuries, those laws have morphed into the bankruptcy laws of today, which tend to favor the debtor but also seek to balance the interests of the debtors, creditors, and society. Although bankruptcy laws were authorized when the Constitution was ratified, it was more than a decade later that they were first passed by Congress. The first bankruptcy statute, passed in 1800, heavily favored creditors, allowing only involuntary bankruptcies. It would be another few years before the shape of the debtor-oriented, voluntary bankruptcy laws that we currently have would begin to arise. Following a financial crisis in 1837, Congress passed the first federal bankruptcy statute that included voluntary bankruptcy. That law so heavily favored the debtor that it was repealed 2 years later. Still, it established the principle that federal district courts had bankruptcy jurisdiction that endures to this day. The next attempt at a federal bankruptcy statute was passed in 1867, but it was repealed in 1888. Finally, Congress passed the bankruptcy statute that would become permanent in 1898. Since then, with numerous changes, there has been a consistent set of bankruptcy laws in the U.S. The 2 major changes to federal bankruptcy law were in 1978 and 2005, though minor amendments to the law are routine. Bankruptcy law closely parallels American debtor-creditor law, but the two are separate legal fields. Debtor-creditor law, for example, includes regulations on debt collection, credit reporting, and wage garnishment. While these are relevant in some bankruptcy proceedings, they can arise when no bankruptcy is filed, or may be irrelevant even when there is a bankruptcy. Debtor-creditor law is the subject of other law shelf courses. Layout of Title 11. Title 11 of the U.S. Code is divided into several chapters that encompass the entirety of statutory bankruptcy law. These include several segments, including the following. Chapter 1 covers definitions and general provisions. Chapter 3 covers case administration, including the all-important automatic stay rules. Chapter 5 covers rules regarding the creditors, debtors, and the bankruptcy estate. Chapter 7 covers liquidation bankruptcies, in which the person will give up all non-exempt assets in exchange for a discharge, or the business will give up all assets and stop operating. Chapter 9 covers bankruptcies for municipalities. Chapter 11 covers debt reorganizations, primarily for businesses. Chapter 12 is a special bankruptcy chapter for family farmers. Chapter 13 allows reorganization of debts for individuals with regular incomes. This course will concentrate mainly on chapters 3, 7, 11, and 13. Jurisdiction. Bankruptcy, by definition, is a federal proceeding and is governed by the Federal Bankruptcy Code, which is Title 11 of the United States Code. The regulations under which bankruptcy law is administered are called the Federal Rules of Bankruptcy Procedure. These regulations are separate from the Federal Rules of Civil Procedure, which govern other civil proceedings. In addition, each local bankruptcy court established its own set of rules. State laws also come into play in many cases as the states have authority over laws concerning property and debtor-creditor relations. Thus, bankruptcy law carves out state property exceptions that detail what property a debtor may keep while declaring bankruptcy. Exempt property varies by state, but there are several reference pages online that list all of them. In addition, two other federal statutes affect rights and obligations in bankruptcy court: the Service Members Civil Relief Act and the Securities Investor Protection Act of 1970. Bankruptcy courts. Bankruptcy court is not a statutorily separate court in the federal court system. Rather, it is a division of the Federal District Court, which is the trial-level federal court. Each federal judicial district in the country has a bankruptcy court, meaning that there are more than 90 bankruptcy courts across the country. Each bankruptcy court has its own clerk's office. Bankruptcy courts may also operate in satellite district court offices in large districts. Each bankruptcy court has one or more appointed bankruptcy judges. There are a total of 350 bankruptcy judges. Unlike other federal judges who are appointed for life, bankruptcy judges are appointed for 14-year terms. Also, unlike most other federal judges, bankruptcy judges are appointed by the District's Court of Appeals rather than by the President. The bankruptcy judge may decide any matter connected with a bankruptcy case, such as eligibility to file or whether a debtor should receive a discharge of debts. However, as a practical matter, most of bankruptcy legal and judicial work is administrative and is overseen by a court-appointed trustee. It is a rare case that is actually heard at trial by a judge, so it is important to understand who these private trustees are. Bankruptcy trustees. Private bankruptcy court trustees are appointed in cases under Chapters 7, 12, 13, and sometimes 11. They are appointed and supervised by the United States Trustee's Office. Trustees are private attorneys who are appointed from a list of attorneys who regularly practice in that court and whose primary law practice is devoted to this area of law. They are not government employees, but they are paid by the court, usually out of the bankruptcy estate. Chapter 7 trustees are appointed to a panel and receive assignments through a blind rotation system, so they're sometimes called panel trustees. Chapter 7 trustees collect debtor assets, liquidate them under the Bankruptcy Code's rules, and distribute the assets to the creditors and generally manage the case. The debtor may have as few as one meeting with the trustees who will go over the case with the debtor and/or attorney, and then send the paperwork to the judge to review and sign. Trustees appointed to cases that are not liquidation bankruptcies, mainly Chapter 11 and Chapter 13 cases, are called standing trustees. Their responsibilities are greater than those in Chapter 7 cases. Standing trustees evaluate the financial affairs of the debtors, make recommendations to the court regarding the reorganization plan, and then administer the court-approved plan by overseeing the collections and payments mandated by the plan. Voluntary and involuntary cases. A bankruptcy can be filed either voluntarily or involuntarily. A voluntary case is one started by the debtor. An involuntary case is started by the creditor or creditors. The vast majority of cases are voluntary. Involuntary cases may be where creditors have no other good way to collect debts from a recalcitrant debtor. There are numerous restrictions on involuntary bankruptcies, as they can only be filed under Chapter 7 or 11, and there are financial restrictions. Foreign debtors. A foreign debtor can file for bankruptcy if the foreign entity has property located in the United States. They will be treated like any other entity filing under Title 11. These actions are independent of any foreign bankruptcy actions. Chapter 15, added to the Bankruptcy Code in 2005, allows the appointment of a representative of a foreign person or business engaged in a bankruptcy proceeding in another country. Once the representative is recognized by the court, the foreign entity comes under the jurisdiction of U.S. bankruptcy laws, giving the debtor all the protections and other processes of the U.S. bankruptcy system. Relief in bankruptcy. Debtors in bankruptcy proceedings seek two objectives. The first is temporary, relief from paying debts while the case is in process. The automatic stay under Section 362 of the Code allows this temporary relief. The second is the permanent relief, or restructuring of the debt at the end of the case, which is called the discharge. The automatic stay. The voluntary filing of a bankruptcy action under Chapters 7, 11, and 13 automatically stops any lawsuits or collection actions against the debtor, the property of the debtor, or the property of the estate. This is called an automatic stay. The stay dates from the date of the filing, even if the creditors do not find out about the filing until later. Bankruptcy courts also have injunctive power to grant stays in any case in which the automatic stay might not be available. The automatic stay applies to most collections actions, including 1. The commencement or continuation of any civil litigation in a court, an administrative proceeding, or any other action whose cause arose before the bankruptcy petition was filed. 2. The enforcement or collection of a judgment. 3. Any act to obtain possession of any property of the debtor or the debtor's estate. 4. Creating, filing, or foreclosing on a lien against the property of the debtor. 5. Creating, filing, or foreclosing on a lien against the debtor personally. 6. Any collection actions, whether or not there has been litigation filed. This includes telephone calls from collectors. 7. Collection through a debt set-off. A debt set-off occurs, for example, when money is taken from an income tax refund check to pay for a debt owed to the state or a bank to set off a fee owed to the bank. 8. Federal or state tax collection actions, under certain circumstances. Actions not covered by the automatic stay include criminal actions or proceedings against the debtor, SEC investigations and orders, any domestic relations court proceedings, including collecting child support, establishing paternity, and property division during a divorce, non-payment of child support, including withholding, suspending or restricting a driver's license or any professional license, reporting overdue child support, intercepting tax refunds, and enforcing medical support obligations, any act by the bankruptcy trustee regarding the debtor's property, and any property that has already been transferred out of the debtor's estate, as in the case where the debtor made a fraudulent transfer to a friend or family member. Debts that are reaffirmed also can be collected, notwithstanding the automatic stay. A reaffirmed debt is one that the debtor voluntarily chooses to pay, even if there is no obligation to do so. These debts could include a mortgage, to keep a house or car, or a credit card debt, to keep the card. Filing a bankruptcy can stop an eviction, but not under all circumstances, and potentially not for a very long time. While the stay applies to any eviction where the landlord has not yet secured a judgment, it does not apply to an eviction that has already been filed and served. Even where applicable, the landlord can object to the stay and follow a formal process in the bankruptcy court that may allow the eviction to go forward. This process may be affected by state law. Some states, for instance, do allow a renter to pay back rent and cure the rent default. The landlord can also continue or start an eviction if the reason for the eviction is illegal drug use. Filing a bankruptcy stays utility shutoffs for 20 days. There is also a process to try to extend that time. The automatic stay will stop wage garnishments. For Chapter 7 cases, this does not include child support, which will continue to be taken out of the debtor's paycheck. The stay will include child support in Chapter 11 and 13 cases, since paying support will be a part of the reorganization plan. If wages are wrongly garnished, state law may allow a lawsuit against the employer to recover the money. The stay lasts until the case is terminated, usually in a discharge, or the debt is dismissed or modified. However, The stay is only for 30 days if the debtor has had a prior bankruptcy case dismissed within the prior 30 days, and there is no stay at all if the debtor filed 2 or more cases that were dismissed in the prior year. In those cases, a stay must be requested by the debtor and may be granted or denied at the discretion of the judge. Lifting or terminating the stay. Any creditor can object to the automatic stay and try to begin or continue collection action. The objection can include filing a proof of claim with a motion for relief from the stay, filing a motion to ratify a foreclosure, or filing an objection to a Chapter 11 or 13 plan. Objections can be either for cause, such as where the debtor has engaged in fraud, or where the creditor alleges lack of adequate protection under the law. The latter objection applies where the lien holder has secured interest in the debtor's property. It can be used when the creditor claims that the property or the lien holder's interest in the property will be permanently damaged unless the stay is lifted. For instance, the lien holder can claim that the stay is costing unrecoverable money by interfering with the sale of a building, or that the stay itself is devaluing the market value of the building. The stay may be terminated under 2 common situations. The first is when the debtor's property is transferred to someone else. This could occur, for instance, when the trustee sells a mortgaged property, allowing the holder of the mortgage to enforce that agreement against the new owner of the property. The second is when the case ends. Discharge. There are several ways in which a bankruptcy case can end. It can be voluntarily dismissed by the party that brought it. It can be terminated for cause by the court for fraud, for violating the rules, or where the debtor has abused the process, like bringing an action with very little debt. Most commonly, bankruptcy proceedings end in discharge, which means release of debts. We will be exploring what a discharge means for each chapter as we go through this course. We will also explore the various reasons that debtors and creditors do not always achieve their desired outcomes under the bankruptcy laws. In the next 3 modules, we'll cover the 3 most common types of bankruptcy filings, those under Chapters 7, 11, and 13 of the Bankruptcy Code.